Evidence law, impeachment. It's important to begin Rule 607, who you can impeach. Federal Rule 607 says that you can impeach your own witness. This is different from the common law rule, though, which prohibited you from impeaching other witnesses. Next, we'll talk about prior statements. This isn't explicitly stated in the federal rules. It's going to implicate the collateral matters doctrine. It's going to be super important for the final exam, but just know you're not going to find the collateral matters doctrine explicitly in the rules, but it's something you're going to have to know, and it's something that's absolutely going to be tested on this final exam. First is a bit of background vocab. Collateral statement is relevant to the case solely because it impeaches a witness. A non-collateral statement is relevant to the case because it implicates a fact of consequence to the case. So it's important, central to the case, determines the case outcome possibly. Extrinsic evidence is any evidence other than the testimony that the witness is currently saying on the stand. So a police report, receipts, last year's tax return, whatever. That's going to be extrinsic evidence. Intrinsic evidence is what the witness says while they're on the stand in that moment. So again, we're going to be talking about the collateral matters doctrine. That's going to be really important. It's not explicitly said in the federal rules, but it is going to be important for this final exam. It's also known as types of impeachment using the witness's prior inconsistent statements. So if you want to impeach the witness based on intrinsic testimony, what they've said in court about a non-collateral issue, remember, intrinsic, what they said on the stand, non-collateral, relevant to the case because it's a fact of consequence, that's allowed. That's fine. You can use their past testimony, the witness's past testimony for fact of consequence to the case. That's going to be allowed. What about if you bring up extrinsic, outside court testimony, receipts, police reports, etc.? Bring that up. It's allowed for non-collateral matters. That's going to be allowed subject to the procedural requirements in 613B, which we'll talk about down here. Just to preview it, though, if you spring this extrinsic evidence to impeach a witness for their prior inconsistent statement, then the witness being impeached must have the opportunity to explain themselves. It's not really explicitly stated in the Federal Rules of Evidence, but we imply that Federal Rule 16B is only for non-collateral matters, doesn't apply to collateral matters. So the rule statement would be under Federal Rules of Evidence 613B. It's not explicitly stated, but extrinsic evidence of a witness's prior statement is only allowed for non-collateral issues. So that's going to be up here. So extrinsic evidence of a non-collateral matter, that's allowed, subject to procedural requirements of 613B. So then we can move on to, remember, intrinsic evidence of a collateral matter. It's allowed. It's going to be subject to some outer limit guardrails of 403 relevancy, right? Balancing. It's also going to be subject to Federal Rules of Evidence 611, and that says, we'll get to that. We'll have to come back to that. So, but what about if you want to bring in extrinsic evidence of a collateral matter? That's the least relevant to the case. It's something outside. It's the tax return. It's the police report. It's the receipt from earlier of a collateral matter. If you're introducing that to impeach a witness, bringing in extrinsic evidence of a collateral matter, that's going to be prohibited except when it shows the witness's bias. Extrinsic evidence of a collateral matter is prohibited unless it shows witness's bias. There's an asterisk here. We talk about it more here. You may use extrinsic evidence of a collateral matter only if it shows that the witness is biased. Professor Hokar in class, she explains that normally we don't use extrinsic evidence for collateral matters. That's the baseline rule. But bias is so important to evaluating the credibility of this witness, and it's important for the jury to be able to evaluate the credibility of the witness, or the fact finder if it's a bench trial judge. So because of this, judges will usually allow extrinsic evidence of a collateral matter only if it shows the witness's bias. That's really important. That's something you're going to need to know. That's such a little caveat that she's probably going to test, so you need to know that. So just a recap: intrinsic, non-collateral, allowed. Extrinsic, non-collateral, allowed, subject to procedural requirements in 613B, meaning got to give the witness an opportunity to explain themselves. Intrinsic evidence of a collateral matter, that's allowed, subject to some outer limit guardrails. Got to pass 403 balancing, obviously, right? So there's something I'm sure you could think of that where it wouldn't be allowed. And it is, you also got to follow the procedural requirements in 611. For extrinsic evidence, that's going to be prohibited unless it shows the witness's bias. So going down to the 613 procedural requirements. For 613A, you don't necessarily have to show the witness's prior statement to the witness themselves, but you must disclose the witness's prior statement to the opposing counsel if they request. So you got to have it ready to go. You don't necessarily have to disclose it, but if the opposing counsel wants it, you got to give it to them. For 613B, if you spring this extrinsic evidence to impeach a witness for the prior inconsistent statement, then the witness being impeached must have the opportunity to explain themselves. It's not explicitly stated in the Federal Rules of Evidence, but we imply that 613B is only for non-collateral matters. That's something you're going to have to remember. 613B, springing extrinsic evidence to, surprise a witness, that's only allowed for non-collateral matters. And that makes sense because, obviously, because of the collateral matters doctrine, extrinsic evidence of collateral matter, that's going to be allowed unless the show witness is biased. So, if you spring this extrinsic evidence to impeach a witness for their prior inconsistent statement, then the witness being impeached must have the opportunity to explain themselves. It's not explicitly stated here, but it only applies for non-collateral matters. That's going to be the rule statement. Now go to 609. Prior convictions and past bad acts. Now, just to kind of orient ourselves, you see over here, we'll talk about 609 first, prior convictions and past bad acts. Then we'll go to 608, untruthful character. 608 and 609 can only be used to impeach a witness. It can't be used to show propensity. And I know we kind of eye roll at this. I know we say, it is going to, the jury is going to draw that propensity inference. But strictly for the purposes of our rules, we're living in this legal fiction land where it's only being used to impeach the witness. Whether the jury catches on, they probably won't, honestly, right? They are going to draw that inference. It's going to be improper. No, that's what's really going on. But just for our narrow legal fiction caps that we have on right now, it's only being used to impeach. It's not being used to show propensity. So Federal Rules of Evidence 609, that deals with prior convictions, not bad acts, convictions. 608 would show the character as witnesses truthful or untruthful. But we're going to begin with 609. Prior convictions, past bad acts. Past bad acts that aren't convictions, that's not going to fall under 609, right? That's going to fall under 608 because 608, you'd have to, have truthful, untruthful, whatever. If you just did a past bad act, though, it's not going to fall within the scope of 609 because it's not a past conviction. If you're not dealing with a prior conviction, then you can only get in the past bad act under 608 if it shows untruthfulness. So don't get tricked here. Past bad acts that didn't get convicted are not within the scope of 609. This is commonly tested, so don't mess it up. Here's some bad acts that are going to show untruthfulness that you'd have to get in under 608, but not 609 because you're not going to get, unless you do get convicted of it, but just by themselves, without a conviction, you're not going to get it under 609. You got to get it in under 608 to show the witness as truthful, or in this case, untruthful. Some past bad acts that show truthfulness or untruthfulness. We got perjury. We have false statements. We got criminal fraud. We got embezzlement. We got false pretenses, right? Some bad acts that probably don't show untruthfulness. We flesh this out in the problems that we'll talk about later, but these past acts, they probably don't show untruthfulness. So if they're past bad acts, you don't get convicted, you're probably not going to be able to get it in under 608 either. You could get it in if they were convicted under 609, but if they do it, everyone knows they did it, and they didn't get convicted, you can't get it in under 609, and you can't get it in under 608 because it doesn't show truthfulness or untruthfulness. That's going to be shoplifting. It's going to be burglary. And it's going to be leaving the scene of an accident. That's a random one, I know, but it gets fleshed out in the problem. Professor says this when we're discussing problem 1 in class, that leaving the scene of an accident doesn't really show untruthfulness for the purposes of 608. But the risk is that once you ask the question to attack the witness's truthfulness under 608b1, then you have to allow, you just have to allow whatever they say. So an example of this, right? This is a pretty good fleshed out example. You just have to take it. You have to, go with whatever the witness says. If I am cross-examining someone and I say to the witness, "Isn't it true you lied on your tax return?" If the witness lies and says, "I'd never lie on my tax return," that's a lie for the sake of this example, right? I'm the cross-examining attorney. I just have to accept it and move on. It doesn't matter that I have his false tax returns sitting right here, in my file folder saying, "Obviously you lied. Here's the fraudulent tax return right here. I have a copy of it." I can't wave that around. I can't do that. The cross-examining attorney just has to accept this and move on. You have to take the answer as it is. I can't pull out a copy of the witness's tax return and say, but I have the receipts that prove you lied on your tax return. This would be extrinsic evidence. The receipts would be extrinsic evidence of a collateral matter, whether the witness lied on their tax return. So pausing there. Extrinsic evidence of a collateral matter. Go back to collateral matter doctrine. Extrinsic evidence of collateral matter is prohibited unless it shows witness bias. Not the case here. It's going to be prohibited. So I just have to accept what they say, and I just have to move on. So I would have to sit there and accept the witness's word statement for it when they say, I would never lie on my tax return. But the advantage for me here is that the jury will probably realize that the witness just lied on their tax return too, and that they're lying here right now. That's going to look really bad for them. And the jury is going to see this witness probably as a little bit less credible. Jury's probably going to infer that the witness is lying about the issue in the present lawsuit too. But one check on this, one thing to keep in mind as the cross-examining attorney, I have to have a good faith belief that the witness actually lied on their past tax return. So, to figure out if 608 applies, right? First thing we're going to have to say is this on cross-examination? You can't do it on direct. I mean, you don't really want to, probably don't want to impeach your own witness. You can under 607, but you probably don't want to impeach your own witness. So is this on cross-examination? That's the first step for 608, because 608 only applies to cross-examination. This is for 608B. Yeah, this is for 608B. Figure out if 608B applies. You have to say, is this cross-examination? Because that's only allowed on cross-examination. And does it show the truthfulness or untruthfulness of this witness? That's going to be 608B1. Or does it show the truthfulness or untruthfulness of another witness that the current witness has testified about? That's B2. If yes to one, and then either 2 or 3. 1 and 2 or 3 above. Then the question can be asked, so long as it passes 403 balancing. You can't ask an insane, out of left field question that has nothing to do with what we're talking about. That just makes them look bad, right? You can impeach them, and it's just got to pass 403 balancing. But now let's talk about the meat of the rule. This whole time we've been talking about bad acts and whether you can get it under 608. But we're talking about 609. Remember, we're talking about prior convictions. So what about prior convictions? That's 609. So start off with the scales. Obviously, we're going to have different scales that we got to deal with. 609 has 2 different scales to keep in mind. Obviously, we have our baseline. We have 403 balancing, right? 609, A1A, that's going to get 403 balancing. I'm going to pull up the rules on my other screen just so I've got it and you can follow along on your own. 609. 609, A1A. The following rules apply to attacking the witness character for truthfulness by evidence of a criminal conviction. A1. For a crime that, in the convicting jurisdiction, was punishable by death or imprisonment more than 1 year, the evidence must be admitted, subject to 403 balancing, in a civil case or criminal case in which the witness is not a defendant. So 609A1, that's going to get 403 balancing. 609A1B gets different balancing. Listen to this. 609A1B, right? Crime that in convicting jurisdiction punishable by death or 1 year in prison or more. The evidence must be admitted of past bad act, must be admitted in a criminal case in which the witness is a defendant if the probative value of the evidence outweighs its prejudicial effect to that defendant at all. If the probative value outweighs the prejudicial effect by 1 ounce, then you admit it. And that's in a criminal case where the witness is a defendant, right? So, yeah, 403, remember, where that's unfair prejudice has to substantially outweigh probative value for it to not get in. Otherwise, it's in. But if probative value is 1 crumb more probative than prejudicial effect under 609A1B, it's going to get in. Now we got a reverse type. We got reverse 403 balancing. Reverse 403 balancing, that's going to apply in 609B. That's going to be a limit on using evidence after 10 years. So this part, 609B, applies if it's been more than 10 years since the witness's conviction or release from confinement for it, whichever is later. So either conviction or release from confinement, ask whichever one's later, start there, and ask if it's been more than 10 years since that later date. Evidence of the conviction is only admissible if its probative value supported by specific facts and circumstances substantially outweigh its prejudicial effect and the proponent gives the adverse party reasonable written notice, right? That's going to be the procedural requirement, 601B2. But 601B1, that's going to be the important part. Its probative value substantially outweighs its prejudicial effect. That's reverse 403 balancing. So think about it. We got reverse 403, or we got at our baseline, 403. That applies to 609A1. That's pretty generous, pretty lenient, most things in. 609A1B gets a different scaling. It gets in only if the probative value is 1 crumb more probative than the prejudicial effect. But for 609B, for the old 10-year-old convictions released from prison, anything from more than 10 years ago, that's going to get reverse 403. It's going to be really hard to get it in. That's going to apply if the conviction or confinement was more than 10 years ago, then you can bring it in only if the probative value substantially outweighs the prejudicial effect. This is called reverse 403 balancing. So with these three in mind, it's an important starting point. We've got 403, we've got something in the middle for 609A1B, and then we've got reverse 403 for 609B. So for 609A2, some examples of, this is kind of what we were talking about a little earlier too. Some examples of prior convictions that involve dishonesty, because for 609A2, that says for any crime regardless of the punishment, the evidence must be admitted if the court can readily determine that establishing the elements of the crime required proving or the witness admitting a dishonest act or false statement. That's 609A2. Some examples of prior convictions that involve dishonesty. This can be perjury, false statements, fraud, embezzlement, false pretenses. Remember, it's kind of like similar to our list from the bad acts thing above. Some examples of prior convictions that don't necessarily involve honesty or truthfulness, even though they're really bad: kidnapping, rape, aggravated assault, assault with deadly weapon. That doesn't involve truthfulness or untruthfulness. It's really bad, obviously. It shows that you might also be an untruthful person. But for 609A2, that's not going to get in under honesty, truthfulness, right? So for 609A2, it wants to know whether the past crime, not the current crime charge, obviously, was a crime of dishonesty. That's an important thing to keep in mind. It's not what the current charge is. It was what the past charge was. Whether you get that in, the evidence must be admitted under 609A2 if the court can readily determine that the elements of the crime required proving the witness admitting a dishonest act or false statement. We know this because the rule says that establishing the elements of the crime required, past tense. So this is referring to the past crime. Was the past crime perjury, false statements, fraud, embezzlement, false pretenses? If so, it must be admitted. That's 609A2. For 609A1B, some factors to consider whether the probative value of introducing past convictions would outweigh the prejudicial effect. Remember, that's going to be the middle standard where it gets in if probative value, if 609A1B, if probative value outweighs prejudicial effect by 1 crumb, then it gets in. Some factors to consider whether probative value introducing past conviction would outweigh prejudicial effect against the defendant: nature of the crime, subsequent criminal history, similarity to the present offense charged, and the importance of the defendant's testimony. You don't want to force the defendant to not give important testimony just because it would have opened the door to prosecute or introducing a bad act from the past. We want to give the defendant benefit of the doubt, every opportunity to testify, and we don't want the risk of, if the defendant has really exonerating testimony for themselves, you don't want to risk them not saying that just because they know they might open the door to the the prosecutor on cross-examination bring up this past bad act. They're just going to look at the importance of credibility in the case. Is it a he said, she said situation? If so, then that might mean it's more probative. So, 608, we got untruthful character. This is the last big long page. 608A. That deals with opinion or character testimony of someone's untruthfulness. 608A says you can't have character witness for a person's truthfulness unless the other side attacks their credibility first. So 2 things you can show for character untruthfulness. It's opinion evidence by a person with personal assessment or reputation evidence. That person must know both the witness and the community that the witness has a reputation in. Next, we're going to move on to 608B. 608B deals with specific instances of someone's untruthfulness. That's specific instances. 608B talks about how on cross-examination, you may inquire into extrinsic evidence to prove specific instances of a witness's conduct to attack the character's truthfulness if they are probative of the character for truthfulness or untruthfulness of either the witness or another witness that the current witness is being cross-examined now has testified about. So to give some good examples here, we had some good examples in class. Let's say the plaintiff is suing their employer defendant, saying that the plaintiff was not promoted based on her sex-based discrimination lawsuit. Plaintiff calls a fact witness Alex with the quotes below in bold. Alex says these things, and the defendant, the employer, wants to impeach Alex. So these are Alex's quotes, and the defendant wants to impeach Alex. So, let's say Alex said that the employer fired Alex, the witness, 1 year ago for embezzlement. This shows bias. Bias is admissible as a motive to lie. She keeps saying in class that you can bring extrinsic evidence of a collateral matter to show bias. So yes, you can ask the witness about specific evidence of dishonesty. That's 608B1. Alex previously said, "You are smart not to promote Cindy. She's really bad at her job." This is Alex's prior statement, so Federal Rules of Evidence 613 would apply here. It's going to say, the witness's prior statement. This prior statement would be extrinsic evidence of a non-collateral matter. You can use extrinsic evidence of a non-collateral matter. Alex convicted 12 years ago of fraud, served 1 year in prison. Probably won't be allowed in to simplicate reverse 403. Remember, more than, convicted 12 years ago, served 1 year in prison. So we're starting from 11 years ago. That's more than 10 years ago. That's going to get to 609B. The employer can't bring in Alex's conviction and release from prison from 11 years ago because it probably doesn't pass reverse 403 balancing stated in 609B, so it wouldn't be allowed there. Big box employee thinks Alex is a liar. That'd be allowed under 608A. It's just straight up untruthfulness, pass bad act, thinks he's untruthful, reputation evidence. You can just bring in a witness under 608A to say they have an untruthful character. What if the big box employee says everyone at big box knows Alex is shady with money? This turns on being shady with money. This is evidence of someone's truthfulness or untruthfulness under 608A. If it shows untruthfulness, then it would be allowed under 608A. If it just shows past weirdness rather than untruthfulness, it would not be allowed under 608A. So that's a general overview of impeachment.